1:31, so we can start. Can't see because of this computer. Is Lynn on? I don't see her. I didn't think I did. Okay,
She
she's
is
gonna.
not signed in yet.
Yeah, I know she had a meeting at 1, so she'll be with us shortly, I'm sure. We decided to divide up the agenda for the meeting. I was going to do the very first thing, which is introductions. I think we pretty much all know each other, but it'd probably be a good idea to reintroduce ourselves for purposes of this committee, and then we can go from there and give you kind of a sense of where we think things are headed. So I'm Steve Miley. I'm the Assistant Dean for Clinical Education at the U of M Law School, and also teach immigration and refugee law. Why don't I call on people, since I can see everybody's names? Kate, you're next.
I'm Kate Cruz. I am a clinical professor of law at Mitchell Hamlin School of Law.
Great. AJ.
Hi, I'm AJ Dordell, staff attorney for the Board of Law Examiners. I'm helping staff the committee and any odds and ends that come up. So,
yeah, many thanks to AJ for volunteering to do this, because he's going to be critical as support for this subcommittee as we go on. So thanks for your help, AJ. Appreciate it. Carol.
So Carol Chomsky, I'm a professor now emerita from the University of Minnesota Law School, and I've been engaged for a number of years on this work. So I'm familiar with what's going on in many of the states and have written comments and things. So I'm happy to be a resource for this committee on what I know about what's going on with alternative pathways everywhere.
Great. Thanks, Carol. Joanne.
Hi, everyone. Thanks, Steve, and thanks, everyone, for having me on your subcommittee. I'm Joanne Kane. I work at the National Conference of Bar Examiners. Probably most of you know it, NCBE. I've worked there for about 13 years now, and I've participated in other states' exploration of new pathways to licensure as I've been invited to do so. Thanks again for having me.
Great. Okay, wait, I've lost my screen for a second. Okay, John.
Hi, everybody. My name is John Koenig, and I'm a lawyer at Frederickson and Byron in Minneapolis, and I'm a member and president of the Board of Law Examiners.
Great. Debbie.
Hi, everyone. I'm Debbie Shapiro. I am the Director of Student Success and Bar Support at the University of St. Thomas.
Great. Logan.
Hi, everybody. I'm Logan Cornett. I'm the Director of Research at the Institute for the Advancement of the American Legal System at the University of Denver. I also oversee all of our work in legal education and licensure. I've done a fair amount of research on minimum competence and lawyer competencies, and similar to Joanne and Carol, I have had participation in several other states as well. So yeah, excited to be a part of this group.
Great. Wade.
Hi, I'm Wade Davis. I'm a professor of business law at Minnesota State University Mankato. I'm also on this committee as a practicing lawyer outside of the metro area.
Great. Ben.
Hello, everybody. Ben Carpenter. I'm a professor at St. Thomas.
Great. Thanks, Ben. Tom.
I am Tom Boyd. I'm a lawyer with Winthrop and Weinstein in Minneapolis, and I'm a member of the Board of Law Examiners, and I am a member of the committee as a whole.
And thanks to Tom and to Emily, who's not on this call, just for the assistance they gave to Lynn and I as we were putting together the agenda and some preliminary items with respect to this subcommittee. So thanks again, Tom.
Well, greater thanks to the two of you for co-chairing and all of you for serving on the subcommittee.
Yeah, absolutely. David, you're up next. Ooh, Dave, you're muted. Still muted. Okay. Let's see. Honest. He's still looking for his.
Okay, I'm here now. Okay, hi, I'm David Schultz, professor of political science at Hamline University. I'm one of the MSBA reps to the committee. Also for absolutely forever taught both adjunct at the University of Minnesota Law School and at Hamline University when it was a separate law school, and now at St. Thomas Law School. So, and I'm also a practicing attorney.
Great, thanks, David. Denise.
Sure.
Hi, I'm Denise Owens at the University of Minnesota. I'm a professor of psychology, particularly industrial and organizational psychology, so people at work. And my role on the entire committee is to look at things from an assessment expert's point of view.
Great. Thanks, Denise. And yeah, I want to reiterate what Tom said about thanking all of you for agreeing to serve on this subcommittee. And I'm going to turn it over to Lynn, who will talk to us a little bit about the mission of this subcommittee and what we're hoping to accomplish in the next few months.
Great, thank you. So I think we've come to a pretty exciting part of our work, which is putting our ideas into a draft report and recommendation as to how we're going to recommend that the court evaluate readiness for practice through a curricular pathway. We will need to have a draft report and recommendations by August, mid-August or before, so that this full committee can review it, which means we will need a drafting committee, and we'll talk about that in a little bit. But the report would really highlight recommendations for how to assess each of the competencies that have been identified in the competency report, either through coursework, through experiential work, or a combination thereof. And so that's our next immediate step. We are also lucky, I see AJ is here with us. AJ has agreed to take the contents of our report and recommendations and then build a draft rule that will be much less specific, but will point to the report and any updates to the report that this committee would make, so that, you know, the rule will be, as I understand it, a little longer lasting and more malleable than the specific recommendations in the report. And so one thing that's going to be important is that each of the 3 law schools have a contributor to that report to say, okay, if there's coursework that lines up with a particular competency, that's what it looks like at this law school, or that these are the kinds of experiences that you could have in our curriculum. And so I think that's the next piece that we need to take immediate action on. I think Steve is going to talk a little bit about what we think the timeline will be to make some of those recommendations, but that's our short-term goal between now and August, is to get that initial report and recommendations pulled together. I lost Steve. Did he fall off the call? He did. Okay. Any questions about that? But while he's logging back on, about sort of the work that's in front of us next? Yeah, Kate.
Yeah, I really I like the approach of looking at the competencies and thinking about how they could be measured in a curricular pathway. I think when we had the discussion on the larger committee about the competencies, it was discussed that some of those competencies might be measured through the character and fitness process, which would still be in place. Mm-hmm. Are we going to also, I mean, do we have to do everything in the curriculum, or can we identify some pieces of the competencies that would be assessed in a different way?
Yeah, I mean, I think that's part of what we would recommend. One thing that I think about as an example is if we have a student who is participating in some kind of experiential piece, maybe there is some kind of evaluation that we ask the supervisor to do that would assess whether there are concerns with any of these abilities to meet deadlines or, professionalism concerns or something. But there may be a reason why faculty wouldn't feel comfortable evaluating that. And so that's something that this committee could talk about, I think. But the board understands that the character and fitness assessment will happen anyway. I mean, that process will run alongside of whatever curricular pathway we recommend. But there may be some insights that these experiences could provide the board when they're evaluating applicants. The other thing that I think is important that I learned in our meetings with Tom and Emily, or I guess maybe I knew subconsciously, but if a student isn't accepted out of this curricular pathway, they still have the option to sit for the bar exam and seek licensure. It's not like an all or nothing thing, like we would deny someone licensure through this process. This is really saying this is a student that the law school feels confident in recommending for licensure based on the following work. And so somehow I feel like that set my mind at ease a little bit about like the level of scrutiny that falls on any individual instructor or that we're really putting forth highly qualified candidates. So I think it's an open question, Kate, but we can make a recommendation on any of those competencies. Carol?
So I'll say one thing about the competencies. As we talked about it in the committee and also with Tom and Emily, the competencies document you have is malleable in the sense that if this group and then the other subcommittee looked and said, this can't be done, this shouldn't be done this way, this should be done a different way. I think my view is we've now taken some things from having helped draft the competencies document. Things were left off there that were kind of in the essential eligibility requirements, but didn't fit this. And so I think we should think about the competencies as things that ought to be covered in this pathway. But if there's something that this group thinks it's more appropriate to do it somewhere else, then recommend taking it out of the competencies in this document. I think this is about the pathways. This is not all the competencies. And that includes revising any of the subparts too. And of course, when I view the competencies, I'm thinking of the big items, not all those lists. And so I think, we have to keep that in mind as we talk. I wanted to ask a question too about, as you talk about coursework and experiential and faculty evaluating, my own view, and I think that this has been shared in the past by others as well, is that this is not about faculty evaluating and shouldn't be about faculty evaluating students for licensure or graduates for licensure. That part of the goal, part of the conversation, I thought would be about creating portfolios or something that the bar examiners still would evaluate and figuring out how that evaluation occurs. There's a faculty role here for sure. In the Oregon version, not of this, but of supervised practice, there's some kind of confirmation by the supervisor about the work, but then the evaluation is being done by bar examiners or by a group of examiners. And I would urge this group, and I hope we're thinking along those lines. So yes, it'll be defining what kind of experiences ought to happen, but what kind of documentation should come out of that and what will be looked for in the documentation, because I think the public and lawyers might be a little concerned if the law schools were doing the licensing, and I don't think the law schools want to be doing that. And I don't think that's the intention, but I assume that part of the process of creating this report is about figuring that part out too, that it would include portfolios that the examiners would look at or something like that's going to be part of it too.
Yeah, and that's what I heard at the last large group meeting, that it would be a shared responsibility in the sense that there would be some evaluation on the school side, but then a second evaluation and confirmation or decision from the Board of Bar Examiners. I think about it, so I sign character and fitness certs for every student here at Mitchell-Hamlin. So the school already makes a determination in one way or another about character and fitness for every applicant, but I don't get to say, based on my assessment or based on the school's records, that this person shouldn't be licensed. That's just one part of the process. And so I see this in a analogous way, that, you know, there would be some way for a supervising person to offer feedback. I don't know what shape that would take, and I don't have a position on that. But that's, I think, what the board is looking for us to share in that responsibility in some way. Joanne,
You know,
sorry, you've had a lot of.
I'm from a Board of Law Examiners perspective, what we're talking about now will be really important from a workload perspective. I mean, the more right now we rely on the bar exam, and I realize when we all look at the core competencies, many of the core competencies aren't examined at all on the bar exam. But you know, the gold standard for the curricular pathway is Daniel Webster, and I don't think the Board of Law Examiners has to do anything. They just rely on what the Daniel Webster Law School did. So you know, we'll have to think long and hard about portfolios, and you know, the way I was thinking about it, and maybe I've been misthinking about it, is there will be a lot of evaluation at the law schools, and we're relying on that evaluation at the law schools to determine competency. And it's a more rigorous evaluation than the law schools do when they graduate people, because it's not diploma privilege.
Thanks for that, John. Joanne, you've had your hand up for a minute. I want to make sure that I get to you.
Thanks. Yeah, I just had a quick clarifying or table setting question. I think we talked about this in the big group, but I just want to make sure I'm remembering it correctly. So when we're talking about this pathway, the focus maybe of the report and some of the conversations might be on the Minnesota law schools, but it would be open to people who had attended law schools out of state, or is it limited to the Minnesota law schools?
I think our immediate focus is on the 3 Minnesota law schools, but it seems to me that if we make the recommendations broad enough that someone could argue that they could meet these qualifications elsewhere, I think it's hard to imagine what that looks like without knowing what other law schools are offering or willing to do. But I think we could conceive of it in a broad enough way that would be, but that's really I guess it's a question for whether we want to make a recommendation that this could be expanded. You know, my understanding is also we're presenting a pilot, and so this committee might make a recommendation about how many students we're talking about, to the workload issue that John raised, that, and I think has been raised by the law schools. You know, do we want to set a target for the, you know, maximum number of students, or, you know, how we identify students for this first part? And then I also think in the back end, how do we evaluate the program? I think that's probably Denise's area of expertise, right? At the, you know, at the end of the day, how do we know that this is working or what? And so we'll have to circle back to that at the end. Carol and then Tom.
So I just wanted to clarify one thing. In the Daniel Webster program, the bar examiners are involved. It's not that the school licenses, there are portfolios, and the bar examiners actually are part of the portfolio review process for 2 years for each of the students. And so in sort of, again, frame setting, even that one, which is a kind of rigorous, particularly structured program, the bar examiners do review portfolios. I also just wanted to suggest, and this is probably part of the drafting, or I don't know, you know, if it's drafting or exploring before drafting, but I think the process that Oregon has been going through in terms of portfolio evaluation and the amount of work for a supervised practice pathway, but nonetheless, it's the one example we have extant of actual portfolio review and how much work it takes or doesn't take. I think that we need to kind of have that in mind, because we have a model for how to do that and to figure out how much work. I'm very cognizant of the fact that we have to figure out a way that works both for the law schools and for the bar examiners, but we have some models to go on that.
Tom, did you have a comment before I go to David?
I did. Just two quick points. One, following up on Carol's point. I think the two issues there are responsibility and scalability. And with Daniel Webster, they've got a small group of people. And I think these the bar examiners kind of pair up with these students, and they're walking alongside them through the process. That seems very, very ambitious. So, you know, it's in a perfect world, that's great, but in a real world, trying to do something, even a pilot program that's of some appropriate magnitude, that would be challenging. But there's certainly going to be responsibility at the Board of Law Examiners. And Lynn, your analogy about signing CNF certificates is a good one. You don't make the decision, but that's information that's really important to us. The second thing, with regard to whether the proposed program would be just focusing on students at the law schools in Minnesota versus eligibility to apply from a law school outside the state and to qualify. I would, it's your committee, so it's for you to come up with the proposals in the first instance. But I would urge you to really focus on what works for the law schools here. And if that can be translated at some point in the future to be available to other people from outside the state, great. But you've got a big enough task as it is. And I think making sure it works for the law schools here is most important.
Thanks for that. That's super helpful, Tom. David.
Okay, a couple of observations. First, anybody who's ever taken my con law class knows that I'm probably the only person in America who likes the Commerce Clause cases. Okay, and the reason why I say that, and I wanted to teach a class just on the Commerce Clause once, and nobody would let me. But I say that because depending on what you're talking about in terms of who's eligible, again, we talked about this before, who's eligible or what law schools are set up to do what, we do potentially run into some Commerce Clause type of issues that I don't want us to forget in the process here. The second thing, and I think I'm going to say it a little bit differently than I think some of the others have here, is that when I'm looking at what students need to pass exams or graduate from law school, that's different than what I think as a practicing attorney, I think somebody needs to be able to do to be able to practice as an attorney. And those are different things that are out there. And I just say that because I'm a little concerned about saying that turning it over to law professors to also make the judgment call about what we need to be admitted for the practice of law. I know in some cases, law professors are admitted to practice law. Sometimes they're not. But I'll be the first to say that the focus of what law professors are thinking about is not necessarily about what you need to practice, but something else. And so I want to keep that in mind also as we're going forward.
Yeah. Noted. Other questions about sort of just the basic task in front of us? I think we have a lot of work to do, and it sounds like a lot of exploration in terms of the breadth and depth of detail that we want to provide in these recommendations. But I think there are many, many different ways for us to get where we're going. We just all have to find a way to agree on that path moving forward. If not, I will turn it back over to Steve to talk about sort of like how in the world are we going to do that between now and August?
Yeah, well, Lynn and I, with help from Emily and Tom, put together a timeline for this group in conjunction with the full committee, because we do have a lot of work to do. And obviously the immediate task is the drafting of the report and recommendations, which we also included kind of a framing statement for that report, which we could talk about, but why don't I focus at least for now on the schedule. And that report recommendation would go to the full committee by mid-August, because there's an August 27 meeting at which that committee would consider, the full committee would consider the report and recommendations. So along those lines, what Lynn and I were thinking is that we will set up a series of regular meetings certainly of the drafting committee, which we will form a little bit later today, because that draft has to be finished by mid-August for presentation to the full committee. This committee, we think, this subcommittee, sorry, on the curricular pathway, Lynn and I think one additional meeting will be sufficient. That will be a meeting most likely towards mid to late July, where we as a group consider a draft of the report and recommendations that the drafting committee has put together. Okay? So just to give you a sense of the, the workload that's involved, the time frame, et cetera. The report and recommendation that's approved by the full committee then goes out for a public comment process, 30 days, and the goal here would be to have that process finished by the end of September. So the draft would need to be approved by the full committee, in late August, so it can go out for public comment. Obviously, this committee and certainly the drafting, this subcommittee, and then the drafting subcommittee of the subcommittee would be considering whatever comments we received during that September comment period, and then revising the report and recommendations in anticipation of a published rule that we anticipate going out soon after the first of the year. But in between then, there's already a full committee schedule meeting for November 5, at which certainly public comments and any revisions based on them would be discussed. We can talk later when when we have the drafting committee set, whether it might be possible between the closing date of the comments and the November 5 meeting for the drafters to come up with a revised draft that then be considered by the full committee on November 5. But we didn't want to get too particular with dates here just yet. And then sometime in December, this subcommittee would get together and review the public comments and review a revised report that the drafting committee had put together, and then that gets passed on to the full committee, which would put that revised proposal out to the public, through comment period in early January, such that that period would end by the end of January 26. And based on those comments, further revisions occur, and then this subcommittee sometime in the early spring of 2026 would present final draft revised report with recommendations and the proposed rule amendments to the full committee. And this is in line with the scheduling order we got from the Supreme Court, which wanted all of this concluded by, I believe it's July of 2026. Yeah, so lots of work to do, especially for a subset of us, which we'll talk about in a second. Any questions about that timeline? I think it's doable. I mean, it's a lot of work, but that's what we all do. So I think it's doable. Carol.
So one a question, and this is partly based again on having watched this process go on in other jurisdictions. There's a step before the kind of drafting work that goes into paragraph after paragraph after paragraph of detail, and that is making judgments about say some bigger questions about the contours of the program, and so I'm wondering if you're thinking, for instance, between now and the first meeting of this whole subcommittee, there would be some discussion in a drafting. I mean, I think the drafters may be the same people who want to look in detail and start to set out some generalities, and then maybe talk with the whole subcommittee, if that's necessary. I'm a little leery of like drafting a report in detail before running the big picture by to make sure that the group is on track of what will be supported in terms of the contours of the program. So I just assume that built into that process will be some of those like steps towards the drafting, so that we're not writing, we're thinking first and agreeing and then writing. So I mean, that may almost go without saying, but again, just because that's about the amount of work that has to be done between now and on this. And I do think it's doable, but it requires, I think, a little bit of that kind of structure to make sure that we don't write ahead of our agreement.
Yeah. That's a good point, Carol. I mean, I'm just thinking off the top of my head, but we could certainly, I mean, if the drafting group gets together, certainly in April, you know, maybe we have a full subcommittee meeting sometime in May to think about, you know, the larger issues, we'll call them, that you've talked about, so that first of all, so the drafting committee doesn't waste its time writing about some things that other members of the full committee are going to think, well, you know, who gave you the okay for this, right? Or, you know, I don't agree with this, you know, we're debating fundamental principles in July when we're supposed to get a report to the full committee in August. So agreed. I think that makes a lot of sense.
I know in Oregon, they were meeting weekly for a while but with a subgroup, and I'm not saying we should meet weekly, but they had a group that was coming and every week or every 2 weeks coming and saying, okay, how about this? Oh, okay, you think that? Oh, then how about this? And so it evolved by having that conversation, and maybe it doesn't have to be a full, you know, it could be a brainstorming group of people who are not in the drafting group, but who are willing to come and talk through. I mean, there are different ways to do it, but, and the drafting group itself will brainstorm those things, but they may have, I mean, it may be, here's what we think for sure should happen, and here's some questions we have. And so I think there are lots of ways to do it, but it requires that to make sure that we're all on the same page at the end.
Yeah.
Sure. Denise.
Yeah.
Oh, yeah, go ahead, Denise.
One thought that I am having, I second Carol's observation and thoughts there, but perhaps bringing what we know from social science into this process might be a little helpful, in the sense that, you know, if each of the competencies are going to be taken, and then what are the different ways that these can be assessed using a curricular pathway, and then it's going to be a brainstorm. That is, the research literature on that says that is best accomplished actually individually, not as a group, not as a committee, because most number of ideas and most diverse ideas come up when individuals are alone, when the loudest voices are not dominating the conversation. So you end up with the biggest spectrum of things. So might I suggest even a document that lists the competencies, and then people just literally going in and dropping in their ideas or submitting their ideas, and then the committee coming together and discussing in a bigger sort of vetting some of those ideas and debating the pros and cons and delving into the things that have been said in those individual brainstorms. Just a little tweak to the process to make this a little bit faster, but then making sure that even good ideas that might be, you know, not repeated by more than one person are not squashed down too early.
Sure.
I really like that idea, Denise. Thank you.
Great point. Yeah. Tom has an intervention, then we'll go to Joanne.
Oh, I'm sorry. No, Joanne, go ahead.
Go ahead, Joanne.
Oh, I think you should go, because I'm embarrassed to suggest this after Denise's great idea, but I'll go ahead. I had sort of a cheat approach to this to help save some time, maybe, which was going to be, if we wanted to, maybe we could reach out to one of the states who had worked a lot on this. I was part of some of those weekly meetings that Carol mentioned, and they did spend a lot of time laying some groundwork. So the suggestion was just going to be maybe if they'd be willing to share whatever draft document they had gotten to. I haven't been involved recently, so I'm not sure where they are with that work, but if they had a closest to final draft they could share, maybe that would save us a lot of time of reviewing that and adding things rather than starting from whole cloth. Though again, I do love Denise's idea of starting and brainstorming everything and not losing any great ideas that people might have. So I don't want to rein people in too much either. It was just the idea that occurred to me as we were talking.
Yeah, because we don't have to totally reinvent the wheel, that's for sure. Okay, David, is that an old hand or is that a new hand?
It's an old hand.
That's an old hand. Okay.
Here's
Tom,
an
you're
old
next.
hand with a new comment.
I've had my camera. I've had my camera off. I just finished class and I was eating a sandwich, and so I apologize.
Yeah,
this is just following up on Denise and the other comments in terms of maximizing the input. I think keeping in mind the public comment period. Oftentimes you do something and you put it out for public comment and it's crickets. Here, I think there's going to be quite a bit of feedback, and ensuring that there's something to respond to gather that feedback and to let that public comment really do the work is going to be really important here. So I just want to, I know everybody here is very conscientious and you're going to put together the best possible product you can do between now and August. But be reassured that even if it's still a work in progress, it's going to be something that'll really generate a lot of feedback and provide you with a lot of helpful and important information to fill in some of the details that you can't do between now and then.
Thanks, Tom. Yeah, our audience for this are definitely not crickets. Carol.
So in the interests also of, these have been great additional suggestions. In the interests of, again, not reinventing the wheel, I wanted to comment on, and Kate didn't bring this up, but the William Mitchell put together a really nice starting idea about how to shape a program like this in comments to the board and the Supreme Court as part of the process that happened much earlier. And we shouldn't forget that too as a source of helpful framing for what the drafting / thinking brainstorming group would look at. Because I think that was, they did a lot of work with a group of people who were focused exactly on this question. And so in addition to what other states are doing, and most of them, other states have mostly been looking at supervised practice, not curricular pathways. We do have, I mean, there are a couple of states that have done the curricular, and we should definitely look at those, but I'm not sure there's a model out there actually that's more focused on this issue than what Kate and the committee that worked at William Mitchell put together as part of the earlier process. So I just want to make sure that ends up in what's being considered here, because it'll be really helpful.
Yeah. I mean, I have a suggestion. I mean, I think all these comments are great, but just in the interest of moving forward, maybe what we do is this drafting subcommittee of the subcommittee is also kind of a brainstorming group, because certainly the brainstormers are, would be involved, I think, in helping to draft this in any event, but just to make it more efficient. But then early on, like mid-April, maybe even, that group, the brainstormers / drafters, sends out to this full subcommittee, an outline, what we think this report's going to look like, what it's going to entail, what's it not going to entail, and certainly consult previous work that's been done by Mitchell. You're absolutely right, Carol. Other states that have done this. Now, maybe it's unrealistic to expect that to happen in 2 weeks, but in any event, the goal would be not to get into too much detail, but at least let folks know this is the direction that we're going in. If you see a real problem with this, let us know. I don't know whether we would need a meeting of this whole group again to get that kind of input, or if we just say, we're going to start drafting. unless we hear something to the contrary. Perhaps. Kate, I see your hand up, and then David with a new hand.
Yes.
It seems to me that there are certain like basic questions that the whole group should decide about the overall framework of this pathway. And I think for example, the division of responsibility between the law schools and the board in terms of evaluating and making decisions, like how does that look? Because if people are drafting things, I'm hearing different things from people on the committee, on this subcommittee today. And so it feels like we need to reach some kind of agreement about what the larger framework looks like before this subcommittee can start drafting. So I don't know if the smaller drafting group can identify, or bring back to this larger group, like this is what we would propose for what the big picture looks like in terms of like, is it going to be a mix of doctrinal coursework, portfolio work from experiential opportunities? Is there going to be a certain required experiential credit requirement as there's been in some other states? Like and then the details of what it would look like would come out more in the drafting. But I think the basic framework needs to have some discussion and consensus or agreement or a vote or some kind of decision in order for a drafting group to move forward.
Right.
Yeah, and I think I heard that's what Steve was suggesting, that a smaller group would come together with some proposed framework answering some of those questions, put that out to the committee for feedback before drafting the details of what that would look like, either generally or at each school. And then, kind of this iterative process where, this is the direction we're taking with some of these big picture ideas. And then, and I think it could run alongside a shared document where folks could provide feedback if they have strong feelings about, say, the evaluation or whatever we're calling that piece at the end, or evaluating character and fitness versus substantive performance in classes. I think both of those things could happen at the same time, but I think it's challenging in a large group like this to spitball all of these things. I think we do need a smaller group to come up with some basic concepts that we can test out on the larger group. But I think we'll get stuck thinking and not doing if we just need to try to move some of these big picture items forward.
So I think that's a good segue, since we've only got about 15 minutes, to see who'd be interested in serving on this subgroup, at least initially, to the brainstorming and putting together an outline that we would, or that it would, disseminate to the full committee sometime later this month for feedback and make sure we have the kind of consensus that Lynn's talking about. Our feeling, Lynn and I, was that subgroup should have at least one person from each of the 3 law schools and a member of practicing bar, outside of whose practices not clinical or otherwise in a law school. And of course, we'll be staffed by AJ. AJ, you have to be on this committee. You have no choice. But anyway, so we'll take suggestions, nominations, whatever. We're not going to have an election. Obviously, we want to keep it not too unwieldy, because then it's going to be hard for it to be efficient. And again, this group is not, the decision makers. We're just trying to put together some ideas for discussion from the larger group, which I think, based on folks' suggestions today, makes a lot of sense. David, you've got your hand up, I see.
Yeah, I actually see. Tell me if you're envisioning 2 subcommittees or 1 subcommittee. And I actually am envisioning 2 subcommittees. One is sort of the subcommittee that comes up with some basic ideas, bounces it off the our larger organization, and then turns it over eventually to another small committee that's the drafters. Because I actually think there's 2 different sort of structures or 2 different tasks being performed here. wondering what your thoughts are, because I'm very happy being part of sort of the drafter. Give me the direction of what you folks are wanting to do. I'm happy to sit down with 2 or 3 other people and do the initial drafting and working it back and forth. So that's my question here. Are you envisioning the committee that's coming up with the ideas for the larger group to also be the drafters? Because I do think it's 2 different committees. I also think it's a better way of carving up the division of labor.
Yeah, that's true. I mean, open to others' thoughts on that. I mean, I'm a little reluctant to have too many different committees.
Yeah.
Not that they'd be working at cross purposes by any means. I mean, maybe the brainstorming committee meets once, in April, and that's it, and turns it over to the drafters. And a lot of the people who are on the brainstorming committee may be on the drafting committee. That's my sense of how this would work out. But Carol, you've got your hand up.
I guess I don't think having 2 separate committees where there's a division of labor and one person is on just one of those 2 committees is going to make sense. But I think we can, since we're going to start with the brainstorming, I think people could volunteer to be part of the committee at the beginning, but not commit to going all the way through. I think that some people, I'm happy to be on both ends of that, to be brainstorming and then continue on for drafting. Other people may be willing to do that. Some others may feel I'd like to be part of brainstorming, but I'm not going to commit to drafting and vetting language. So I think if we start with a subcommittee that starts with the vetting and discussing and brainstorming, and then it evolves into a drafting committee, some people may stay on for the whole, and then some additional people may say, okay, now, like David, I'm ready to join at this stage, but I don't know that we need to separate out 2 subcommittees at this point, because I think there will be a lot of overlap in some.
Yeah.
I will be an overlap,
Yeah.
but there may be others as well.
Yeah, I agree. I think that makes sense. Joanne.
Just wanted to share how Oregon did this, and I thought it worked fairly well. They had a slightly smaller group because it was pretty much just 3 law school deans and then a small handful of other people, but they had a Google Doc if the group would be comfortable using that, and that's sort of similar to what Denise was suggesting. So got a basic outline, and then anyone, as they had time, you could do it asynchronously, could add comments or questions or yes ands or whatever, and that, if we're just trying to generate a whole bunch of ideas quickly, that might be a little bit more efficient than passing things across individuals on a subcommittee. So again, just because I saw it work pretty well for them, I wanted to suggest it here.
Yeah.
What we
I don't
do,
disagree. I don't disagree. I just always remember the old adage, too many cooks spoil the broth. There was a great article, was it in the Washington Post? Or I know it was The Economist last week, all about the tyranny of Google Docs. You set it up with Google Docs. If anybody else saw the piece too, you have too many people commenting on too many different things. At some point, I think you do have to have a small number of people who are actually doing the drafting at the end of the day. I'm perfectly happy with Carol's suggestion, but I'm a little hesitant about having too many people do too much drafting, because we'll wind up with an unwieldy document. And I hate to say this, we're all lawyers. We all think we can outdraft everybody else.
I wonder if it would be helpful to just do a quick poll of like the 3 law schools. If there's some volunteer from St. Thomas, I guess you'll have to rock, paper, scissors it to be on this initial committee. And just so that we have the 3 law schools covered, and then at least one member of the bar, and then we could take additional volunteers. But it seems like maybe we should sort of focus in on who's in it for the long haul. And I think we need at least one person from each law school to commit to seeing it through. Debbie, did I see your hand go up? Or Ben, you guys will have to like Hunger Games over it. I don't know how that works.
Pencil us in and we'll talk to each other and make sure we're there. So.
One of the 2 of you will commit to this process. Okay. Kate, Steve, you're raising your hand.
Sure. I was going to probably be on it anyway as a co-chair, but I can certainly represent the U on this.
Okay. Is there anybody from the U that's not on the call today, Steve?
Yeah, Kim, but I don't know that I guess she's not on this subcommittee.
Okay. I'll leave that to your internal politics.
Okay. Yeah.
Kate, I'm I'm looking at you because you're a member of the faculty, and I feel like that's an important role for you, but I don't want to put you on the spot.
I'd be happy to do it.
Okay. So that gives us full coverage from each of the law schools. Then we need someone a member of the bar, I think. And then we can take other volunteers too.
I'll volunteer.
Thank you, David. All right. Carol, you said I already had your name on the list because you said you wanted to do the whole thing. Is there anybody else who feels like they will miss their life's work if they are not on this initial brainstorming drafting committee? AJ, you're already drafted.
AJ has no choice. Carol?
Yes.
I was going to see if I could, and maybe Tom was thinking he would be anyway, but I wanted to volunteer Tom because I think that's an important voice in this brainstorming piece for sure, because of the role with the board and practicing law and driving this whole bus from the beginning anyway. So I hope Tom will be part of the group. And that's another practicing lawyer too, which is helpful.
Yeah, I mean, mindful of not making it unwieldy, but if it works, I'd be happy to do that.
I think what's been really helpful for me, Tom, is that you've come in and clarified really quickly answers to some high level questions that this committee doesn't have the backdrop for. And so I think you could be as involved as you want to be, but that's the purpose of kind of keeping us on track without getting sidelined with questions we can't answer is super valuable. So
okay, I'd be happy to.
Yep.
So that gets us to 7. Is there anybody else who's feeling at this moment left out? Okay. You were going to say something, Steve. Sorry.
I was just going to say, just thinking next steps, Lynn. I mean, we should get together, maybe rough out an outline for this subcommittee.
Yeah. I mean, I think
the brainstorming group and get that out before the end of this week, basically. And in terms of a timetable for that group, and then for the larger subcommittee as well. And we want to set up a couple of meetings in April, however we want to do it. But we, rather than making decisions right now, we could put our heads together and make some suggestions to the other members of the brainstorming group.
Yeah, and I do think, to Carol, and I think Joanne's point, the meeting more often in the beginning is probably a good idea, and we can always cancel meetings if we're so efficient that we don't need to talk anymore. But I feel like we're going to hit some really important momentum here once we start unpacking all of this. Debbie, did you have a question or a comment?
Yeah, comment. I still really like the idea that Denise brought forward about having that Google Doc, even if you have like 7 people, maybe 8, or depending on who wins with Ben and I. But if so say I win the rock paper scissors, and Ben's like dying to give some input, and now he doesn't have that opportunity. I really think just even if they have a Google Doc and just the 7 or 8 work on it, but even if people have like side comments, even if it's not like the majority of the comments, but just to have an opportunity to give their input, I think would be really important too.
Yeah, I like both of the ideas of commenting on the competencies and also on any ongoing draft or framework. I think that makes good sense, and we can set that up.
Yep, I agree.
Can I just ask? I was trying to find on my calendar, but AJ and Tom might know. There's a meeting set up to hear from the South Dakota Dean about their program, which seems to be relevant to the conversation from this subcommittee, and I can't remember when it is.
It's
May 5.
April 23rd.
April 23rd.
Yeah, April 23 at 1 o'clock.
Yes. Yes. Okay. Because that'll be helpful too. I think that's the brainstorming group might want to all be part of that if they
Yeah.
can. But
and the dean expressed an interest to field questions. So, I think that's a great opportunity to have a discussion with him and, to maybe throw out some of those ideas to get his reaction.
Mm-hmm. Yeah, so it might be good for this group to meet before that, to have some questions lined up and then to be prepared to move on whatever information we gather at that meeting.
Yeah. I imagine, I think what'll happen is there'll be a when can we meet poll sent out by Mackenzie fairly soon for the for the smaller group, and maybe it'll be a like you suggest, Lynn, maybe a weekly meeting that we can always cancel, but at least we've got a mutually convenient time set up and go from there. Cool. Great. Anything else? Great. Thanks, everybody. Really appreciate
Yeah, I'm
all
excited.
the input. This was a really good meeting.
Yeah.
Excellent. Great.
Thanks, everybody.
Thanks.
Thank you, everybody.
Thank you.
Yep. Take
Thank you.
care. Have a good rest of the week.
Bye.
Bye-bye.